Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, we're ready to hear argument in number 19-1862, Ayala versus United States. Counsel, you may proceed.
Thank you, Your Honor. Good morning. May it please the court, my name is Mark Stevens, and I represent the plaintiff appellant Juan Blanco. I'd like to reserve 5 minutes for rebuttal. We're asking the court to hold that the government does not have the discretionary authority to detain and deport U.S. citizens under civil immigration laws. The district court wrongfully dismissed the complaint based on the discretionary function exception. This exception involves a threshold inquiry into whether this is the type of tort for which Congress has waived sovereign immunity. The district court erred by focusing on the investigation, which is not the conduct that we're challenging. The district court also erred in finding that factual determinations are discretionary, reasoning that immigration officers must evaluate the factual circumstances they encounter and use their judgment. Judging whether a fact is true is not the type of judgment that is protected by the discretionary function exception. It's the discretion to make policy judgments, not factual determinations. This exception applies if two conditions are both satisfied. First, was the challenged action the result of judgment or choice about the best course of action? This prong is not satisfied if a federal statute, regulation, or policy mandates a course of action for the government to follow. The second part of the test is whether the challenged action was based on considerations of public policy, meaning economic, social, or political policy. Turning to application of the first part of the test, the first part of the test is not satisfied here because the government has no authority to arrest or detain U.S. citizens. The amicus brief does a good job laying out all the statutes, policies, and constitutional provisions that mandate DHS not to detain U.S. citizens. That's at page 9 to 10.
Keep using the word mandate. I'm not sure that I see a mandatory directive here from a statute or regulation, because when you look at 8 U.S.C. 1357, that talks about granting immigration and officials power to arrest when they, quote, have reason to believe that someone is violating immigration law. And the words reason to believe seem to me to state a degree of judgment involved and a degree of discretion involved. I don't understand what the mandatory directive is that would overcome that language in the statute.
Yes, Your Honor. I think the best mandatory directive here, the clearest one, is 18 U.S. Code 4001, and it says, no citizen shall be imprisoned or otherwise detained by the United States except pursuant to an act of Congress. Now, that statute that you're referring to, 1357A2, it says that DHS may detain an alien if they have reason to believe the alien is removable. So that does not extend any authority to detain U.S. citizens because it's specifically focused on aliens. And then there's also the fact that agencies don't have inherent powers to enforce law. They have the powers that are given to them by statute. And if you look at all the statutes that give them power to detain people and start removal proceedings, all the statutes only mention aliens. So they don't mention U.S. citizens. And because of these mandatory directives, the discretionary function exception does not apply. And the analysis should end here. The analysis is simple and straightforward. We identify the challenged action, and then we identify whether that action is governed by mandatory laws that dictate a course of action for the government to follow.
Counsel, this is Judge Harris. You started by saying that the district court erred in focusing on the investigation. And so as I understand your position, you agree with the district court that how the officers conduct an investigation, that part itself has an element of judgment or discretion. Is that right?
I do, Your Honor. And I think the thing is, I'm sorry.
No, I just want to make sure I understand your argument. So that is discretionary, but then when the agents draw a conclusion from the investigation and apply the law to whatever facts they found in their investigation, that is no longer a matter of judgment. Is that right?
Yes, it is, Your Honor. That's essentially our position.
Okay. Sorry. No, I just want to get to my app. I just want to make sure I fully understand. So your position, and you say this in your brief very clearly, is that applying undisputed facts to law does not involve judgment or discretion. And that right there is where I would like you to sort of explain to me how that can be right. And I feel like this is maybe a particularly hard case to make to a bunch of appellate judges, since this is sort of what we do for a living, is apply facts to law, and it seems to me at least like that often involves some judgment. So why is that a judgment-free exercise?
Yes, Your Honor. So it sounds like you're referring to the citizenship statute, former U.S. Code 1432A. Mm-hmm. That statute is not worded in discretionary terms. It says that someone becomes a citizen upon the fulfillment of certain conditions. So the only thing that is left for the officer to do is identify when those conditions are satisfied. But the conditions are things like legal custody or actual and uncontested custody. And, applying those standards to a set of facts can be difficult. It can involve some judgment. Yes, it can definitely be difficult. And just because I'm saying that the discretionary function exception doesn't apply, that doesn't necessarily mean that the government is liable. If they do a reasonably good job, it may turn out that they're not liable in this case under these facts. But the statute is not worded in discretionary terms.
Well, the question I have to follow up on what Judge Harris is saying. If we try to separate investigation from arrest and detention, that would be an oddly segmented view. Way any criminal process or immigration process would proceed, because the investigation and the arrest and the detention seem to me to be part of a single sequence. One follows from the other. You can't have an arrest without an investigation. Or can you have a detention without an investigation? And I think the Ninth Circuit recognized that these different phases were linked, and they recognized this in the Ruiz case. And if we were to try to separate them, we would be creating a circuit conflict, would we not? I don't believe so, Your Honor, because that's an unpublished case and it's relatively short, about one page. Maybe the reason that it's unpublished,
right?
Because the Ninth Circuit thought it was really easy. That's the kind of thing that we, sometimes do. Unpublished opinions are things that may not merit publication because they appear to the panel to be very straightforward.
Yes, Your Honor. So the investigation, the detention, and the removal are all linked for the purposes of determining liability at the merits phase of this trial. But we're at a preliminary stage. We're looking at a threshold inquiry into whether the challenged actions are governed by any mandatory laws. And so we have to identify what the challenged action is and whether it's governed by mandatory laws. So the mandatory laws that govern discretion investigations, they're relatively loose. Some of the current memos obligate them to investigate claims to U.S. citizenship, but we're not relying on that. We're saying that the challenged action is detaining a U.S. citizen, and that is clearly not discretionary. And we're saying that they ought to...
Back to what Judge Harris said, that a lot of times applying facts to law and a lot of times deciding whether the investigation is whether the investigation is whether arrest and detention are warranted. That follows from investigation, and it would be an act of judgment, all in itself. In this instance, the whole situation was confusing in this sense that we were talking here about this wasn't a cut and dried matter. There was confusion, I suppose, because it was a question of derivative citizenship, not a question of birthright citizenship. And then adding to the murkiness of it all is the fact that there was an admission before the IJ in August of 2004 that he was not, he said he was not a citizen. And you say, well, doesn't matter, derivative citizenship is still citizenship, and can't take the August 2004 thing at face value. So even if he was negligent, that still, under our case law, negligence doesn't bring somebody outside the scope of the discretionary function exception. And so you ask why that is, and it's because of the way the statute is worded, and that is, that the exception to the waiver of sovereign immunity still it still applies, even if there is negligent conduct, because the statute says it applies even if that discretion is abused. And that seems to suggest, well, even if the discretion is abused, it still applies. Congress meant this to shield certain discretionary functions of the federal government, particularly one as sensitive as immigration law, from this kind of tort suit. And to me, when you couple the language "reason to believe" with even if that discretion is abused, it seems to me to present a pretty sound case for immunity.
So, Your Honor, these sorts of points that, they were looking at a complicated question that's difficult to assess, and, Mr. Blanco may have conceded something at some point, those are all important points at the merits and or liability phase of this trial. And I recognize perfectly well that under the facts that we have, it may well be difficult for us to prove liability. But the issue is we weren't even allowed to get there.
You say, this should wait until the liability phase and this should be further into it. But you do have cases like Mitchell v. Forsyth, which says if immunity is going to mean something, it has to be applied sooner rather than later. And because the immunity is not only an immunity from liability, but it's an immunity from going too deep into the litigative process, and that's what. And at least there are a number of Supreme Court decisions that apply that. I think they may be less persuasive in an area other than litigation over immigration enforcement, but that's those decisions are there, and they talk about immunity as immunity from suit, not just as an immunity from ultimate liability. You can lose an immunity if you go through what we all know can be a laborious process attendant on litigation.
Yes, Your Honor. The problem with trying to assess liability now is we haven't developed a factual record, and I think
I'm sorry, counsel. Go ahead, finish. I want to.
Yeah, I think that
I just want to make sure I have time.
Yeah, I think the case which best explains this is Caban v. United States. It's a Second Circuit decision cited in the amicus brief, CABAN, and it basically recognizes that law enforcement officers, they do have a lot of powers and they have a lot of protections at the merits phase, but that doesn't make the discretionary function analysis and the mechanical duties of identifying whether someone meets the criteria for entry to this country. That doesn't change that into a discretionary determination.
Counsel, I just want to ask you one last question, for me at least. You referred quickly to there have been some directives since the time of these events that have been issued, and I know we now have this so-called Morton memo that kind of walks officers through the steps they need to take when there's a question as to citizenship and requires that they consult with counsel, and I think the facts of this case make clear why that is probably an excellent idea. But just in reading that directive, it struck me that that's sort of what's missing from this case. That looks like Berkowitz, like here's a particular set of steps you have to go through in making your determination. And it seemed to me that almost sort of highlighted what we don't have here. And I just wanted to give you a chance to respond to that concern of mine.
Yes, Your Honor. I think you can look at this case, there's different parts of the facts here. Did they investigate? Our position has always been that they investigated just fine. They got all the facts that they needed. Then there is the application of law to those facts, and as I've tried to explain, that's a mechanical function of just judging facts. And then there's really the core of our complaint is that they detained a U.S. citizen, and that is not discretionary. And I think a lot of the government's defenses, such as that Mr. Blanco, may have conceded alienage at some point, I think that goes to the merits of the claim and not this threshold question, which is where we're supposed to identify the challenged action and ask whether that action is governed by mandatory laws. So I see my time is up, and so unless there's any other questions, I'll reserve the rest of my time.
Judge Harris, do you have any further questions?
No, thanks.
Judge Richardson?
No, thank you.
All right, let's hear from the appellee's counsel here.
Good morning, Your Honors. May it please the Court. My name is Elizabeth Spavins. I represent the appellee of the United States. Other courts have looked at claims arising out of virtually the same factual circumstances. Your Honor mentioned the Ortiga-Ruiz case in the Ninth Circuit, and those courts have almost universally held, as the district court did here, that the court lacked jurisdiction to consider appellant's suit because of the discretionary function exception to the FTCA's waiver of sovereign immunity. The discretionary function applies to the United States' decision to investigate Mr. Blanco's immigration status and to adjudicate his claim to derivative citizenship in 2004, which led to his detention and removal in 2004 and subsequent detention in 2015 and 2016.
Counsel, this is Judge Harris. Can I ask you a question about the sort of the breadth of your position on this first prong? What if there's an ICE agent who's arresting and detaining people born in the United States to immigrant parents who may or may not be documented, and his emails, when they show up, say that, look, I just determined these people are not citizens because I can't confirm that their parents are documented, and I think that birthright citizenship is made up, and that's not what the 14th Amendment means. So he detains them, they're deported. Is that an exercise of discretion that would be protected under the discretionary function
No, I don't think so, Your Honor.
Why not?
Many of the cases, again, Arturo Ruiz being an example, specifically call out that if there's no allegation of intentional misconduct.
There's nothing intentional. This is the officer's best understanding of the law. He made a legal mistake, but it's a good faith error. He did not understand that the 14th Amendment birthright citizenship clause would apply to these people. Absolutely.
Well, Your Honor, framed that way, there is the other distinction, the other area of law which wasn't discussed in the previous part of the argument, which is that individuals of foreign birth, they carry the burden to demonstrate citizenship. So in your hypothetical,
how does that change whether or not the officer here is exercising a discretionary function? I mean, you would say this is a discretionary function, and what flows from that maybe would be different, but, or are you saying this one is not discretionary for some reason?
I would, what it sounds like is the facts, as you laid them out, Your Honor, are more in line with what courts have specifically noted, that if there's some example of intentional misconduct, intentionally disregarding a birth certificate, which is what if I misunderstood, I apologize, but these individuals were born here, but the officer was, as you said, disregarding.
He made a legal mistake. He made a really obvious legal mistake, which is what happened in this case. I mean, we know what went wrong here, right? The officer just misunderstood the law, and he thought because the custody was not set out in the divorce decree, that meant that this person was not eligible for citizenship, and that was just wrong as a matter of law. So I'm just giving you barely even a hypothetical. It's the same question. I've just made it a little nastier.
Well, Your Honor, as far as an obvious mistake or not, the question of actual uncontested custody is a complicated factual question. Cases that the appellant cites in their brief, such as Kamara v. Lynch, demonstrate there are a lot of factual questions inherent. So it's not such an up-down determination, that question of actual uncontested custody, which is distinct from an individual who was born in the United States with a birth certificate that demonstrates that. So I do think the
but counsel, that doesn't. I'm sorry, this is Judge Richardson, but don't you have to make that decision on sort of a categorical basis? So either the determination is discretionary or it's not. I don't think we get to say, well, in this case, it seems rather obvious, and so it's no longer part of the discretionary function. I mean, I'm having trouble understanding how you can draw that line. I thought the answer to Judge Harris's question was just going to be, listen, that guy ought to get fired, and there are lots of possible answers, but it's still a discretionary function.
Yes, Your Honor, I would agree that the inquiry that all the courts, virtually all the courts have looked at is this question of who to investigate, how to investigate, whether to prosecute, are these classic discretionary determinations, as you said, at sort of a high level. What I was endeavoring to draw the line was, which is what other courts have distinguished, is this question of intentional misconduct versus, and there are different hypotheticals of what that could be. Judge Harris's is one of those, but that's the line I was attempting.
No, my hypothetical is not about intentional misconduct, just to be clear. My hypothetical is about a good faith legal error.
Okay, so, Your Honor, I guess then the line the case law draws is between intentional misconduct and negligence. And the statute is clear, the discretionary function exception, if that discretion is abused, it is still encompassed in this exception to the waiver of sovereign immunity, which I think addresses Judge Richardson's question, which is that how are we supposed to draw these lines? Well, the statute draws the line that the discretion can be abused, and nevertheless, the conduct still falls within the exception.
Counsel, this is Judge Wilkinson. I think a partial answer to your point, and I think it's difficult to and I want to get into a difficult line drawing process and say, well, it all depends, because I'm concerned that we would be gutting the discretionary function exception the same way you would with absolute prosecutorial immunity if you said, well, there is this immunity and it is absolute, but on the other hand, it all depends. So with respect, I think Judge Richardson raised a good point that it's either there or it's not, and you say, well, is this too harsh a position? And I think you get back to the old Bivens question, which is, are there alternative remedies to safeguard against the kind of very unfortunate situation that my friend and colleague Judge Harris posits. And you do have an alternative remedy if the discretion is abused, or if a legal mistake is made. And the alternative remedy, the remedy is not a suit under the Federal Tort Claims Act. The remedy lies in the very elaborate administrative removal process that we have to guard against these kind of mistakes. And it'll go before an IJ, and then it'll go before the BIA, and then it'll go before the courts. And it's a pretty elaborate process, and it operates as a corrective when an immigration officer makes a bad judgment as to whether investigation and arrest are justified. And you can certainly, and obviously, one of the first things you would say before an IJ, and it probably wouldn't even get before an IJ because it would be cleared up before that hearing. But the whole thing has to work in some sort of harmony. And what you have is the discretionary function exception to protect against allegedly wrongful arrest and detention, and then to protect the individual officer from liability. But along with that protection of the individual officer from liability, which could chew up the immigration enforcement system, you have this administrative and judicial process to backstop grievous errors. So fortunately, I don't think we have any intentional harm, but I do think you can. I worry about diluting the immunity if we hold that it is something less than categorical. And do you understand what I'm saying? If you get into a situation, well, it applies here, it doesn't apply here, and the rest.
Your Honor, and I would completely agree that the purpose of the the safeguard, and we laid this out in our brief, the safeguard for any. That's
the backstop, not a tort suit.
Right, that's right, Your Honor. And that's certainly what happened here. Plaintiff was counseled during the immigration proceeding, and according to the documents that were in the record before the district court, based on plaintiff's admission, and he didn't seek any relief from removal, he was ordered removed, he didn't appeal that. Those are elaborate processes that are in place to give individuals a path to challenge or dispute any determination by the government that they disagree with regard to their immigration status.
Counsel, sorry, Judge Harris, you go ahead.
You go. Mine is good.
I just want to give you the chance to respond to an argument that's not really developed too much, but we decided a case sort of in the midst of briefing called Sanders versus United States, in which a FBI employee was charged with investigating in some respect with respect to the NCIC records for buying guns. And the court there recognized, I think as we have here, that you don't generally have a mandate in an investigation, but Sanders went on to find a mandate in the operating procedures there, requiring follow-up under certain circumstances. And I just wanted your take on why you think that case doesn't apply here. And I guess there are a couple of different avenues that you could go, but instead of positing an answer, I'll let you give an answer. Why is this case not like Sanders?
Yes, Your Honor, for a few reasons. First, based on this court's case law, the question is not if there is necessarily one particular mandate somewhere in the universe of law, but rather the inquiry is whether you look at the statutory scheme, you look at the conduct as a whole to determine whether it's discretionary, whether it involves an element of judgment or choice. And cases are numerous that have held that this is quintessential discretionary activity, specifically looking into immigration status, determining a person's...
Right, but that's not fundamentally different from what they were looking into in Sanders, right? This is an agent trying to determine the underlying nature of an arrest, right? I mean, that strikes me at a structure point. I understand your structure argument, but I don't understand how the investigation in Sanders is fundamentally different than the investigation here. And Sanders says even though it's discretionary as a general matter, this one operating procedure requiring follow-up under these circumstances was sufficient to overcome the discretionary function exception.
Yes, Your Honor. So I'm not aware of a parallel operating procedure that was pertinent in the 2004 investigation. So that's one answer to your question. And the
all right.
second
So
answer
if that's give me the second answer, and then I will come back to the first one for just a second.
Okay, and then the other answer is I just would point to other statutory and regulatory authority. The district court cited, Judge Wilkinson noted 8 U.S.C. 1357, 8 CFR 287, 8C2 Romanet I, that do give the discretion in looking into this exact situation.
All right, but so why don't I think that 4001 is a operating procedure? That is like, don't arrest citizens.
So that's not an operating procedure in the facts of this case because of the facts which are taken as true in the complaint, which is that the plaintiff did concede that he was foreign-born and then proceeded to not carry his burden to demonstrate citizenship. That's a well-established area of law that I think would easily distinguish Sanders because this is not a situation where the citizenship was in some sense predetermined. The case law says that an individual of foreign birth has the burden of coming forward with evidence of citizenship.
Yeah, Judge Harris, sorry. Thank you.
Okay.
Do you have anything further, counsel?
Yeah, I'm happy to continue. I just wasn't sure if Judge Harris had another question.
No, thank you. I'm fine.
Okay, I'm sorry. So quickly, I just wanted to know that in the alternative, the court could affirm the district court's dismissal on alternative grounds, which we've laid out in our brief. And we would say that the district court properly concluded that the FTCA precludes appellant's case here. There is no waiver of sovereign immunity. We ask that you affirm the ruling of the district court.
All right, thank you. Counsel, you have some rebuttal time.
Thank you, Your Honor. So one quick factual point. Our complaint never stated that he conceded alienage, and the government hasn't provided direct evidence of what he did concede, just secondhand evidence. And one legal point, in response to Judge Harris's question about intentional wrongdoing, I know that the district court decision here mentions that the exception might not apply to intentional wrongdoing by law enforcement. But if that's the case, then that would limit the torts to malicious prosecution. And that's contrary to another subsection of the same statute, which is 28 U.S. Code 2680H. It says that law enforcement and investigative officers may be liable for assault, battery, false imprisonment, false arrest, and abusive process, not just malicious prosecution. So This is a point that's made in Kaban, that Second Circuit decision that I mentioned. And so I know that these are separate subsections, but you cannot view them as accomplishing completely contrary things. And so if you overexpand the discretionary function exception, as the district court did, then you butt up against this other subsection H. And unless there are any questions, I think I'll leave it at that.
Judge Harris, do you have any further questions?
No, thank you.
Judge Richardson?
No, thank you.
All right, thank you very much, Mr. Stevens. We appreciate it. And we will we'll go into our second case as promptly as you can.
Thank you. The court will take a brief break before hearing the next case. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Conference recording has stopped.
All right, we're prepared to...
Can you hold for just 1 second? Something's happened with the conference recording. Bear with us 1 moment.
This conference is being recorded. Only the main conference is recorded.
Sorry about that. You can continue.
May we proceed?
Sir.
I'm sorry, we can proceed?
Sir? Yes, sir, you can proceed.
All right, thank you. We're prepared to hear argument in number 19-6871, Gentry v. Robinson. Mr. Shaw, whenever you're ready, sir.
Thank you, Your Honor. Good morning, Your Honors, and may it please the Court. Devian Gentry should not be forced to choose between betraying his religion and rotting in solitary confinement. Now, there are a lot of issues and claims in this case, so I'd like to focus on the following 3 points. First, Mr. Gentry's equal protection claim should be remanded for development of an appropriate factual record. This claim was dismissed on the pleadings below without the opportunity to engage in discovery, and that dismissal turned on a pure error of law. Second, Mr. Gentry's Arlupa claim is not moot because he appropriately requested broad injunctive relief under this court's precedents, and he still stands to gain from entry of an injunction. Third, Mr. Gentry's First Amendment claim satisfies each of the Turner factors, and thus his forcible intake shaving, as well as his years in solitary confinement in order to practice his religion, violated his constitutional rights. With respect to the equal protection claim...
Counsel, actually, I'm so sorry. This is Judge Harris. I am trying to sort of figure out, as you say, there is a lot going on in this case, and I'm trying to figure out how the claims fit together. And so I have a question about your free exercise claim under Turner. The defendants are arguing that at a minimum they would be entitled to qualified immunity on that claim based on case law that approves the grooming policy at the relevant time. And I didn't see you arguing in your reply brief that that was wrong, that there was a clearly established violation here. And I understand you want us to go on and reach the merits anyway, which is something we can do. But you are not arguing, are you, that there is some clearly established law here that would allow for the recovery of damages under this claim?
Well, Your Honor, I think there is clearly established law on that fact, and I think Greenhill, which was decided after this case finished briefing, recognized that it was decided based on established jurisprudence. I think the first point to note is that qualified immunity looks for clearly established law, but it's not necessary to have a case that's directly on point. Existing precedent just has to have put the constitutional question beyond debate. The other point I would make is that this court's decisions recognize that the right that is in question in the clearly established law is actually the right, not the right to relief. So, in Wall v. Wade, I think this court recognized that when it recognized that the prisoner had a clearly established right to a diet. And then later,
Counsel, this is Judge Richardson. Neither you nor your colleague cite our prior decision in Hines versus South Carolina Department of Corrections, but that's a case where we looked at gotta have short hair, Department of Corrections policy, and found it reasonable under the Turner factors, finding all four weighed in favor of the prison. So, understanding the other arguments you're trying to make, what I can't understand is how you get around that for qualified immunity.
Well, Your Honor, I think that the question of whether there's clearly established law establishing a right is separate from the more factually focused issue of the Turner factors. I think the Turner
right,
factors...
but Hines is a case that literally rejects, like, what seems to me at least to be a virtually identical argument. And so it's really hard, understanding the argument you're trying to make about a generalization, which the Supreme Court questioned, but where we have a case that directly addresses a you must keep your hair short argument under the free exercise clause and walks through the analysis and says, no, that claim fails, you got to give some story for that, don't you, to get around qualified immunity?
Well, Your Honor, I think that whether a claim fails because suppose that there was no easy and obvious alternative at the time, or because, you know, under the facts that were presented by the plaintiff, there was, you know, not enough going against the other Turner factors. I think whether a plaintiff prevails on a claim does not define whether the right itself was clearly established. And I believe in Hines, the court found that there was a substantial burden, just that, you know, it was justified by the legitimate penological interests. But the fact is, you know, even under this court's ruling in Couch v. Jabe in 2012, the court found a substantial burden by being forced to shave under the grooming policy that preceded the one at issue here. So I think that the right itself is established, and, you know, if Mr. Gentry's fact as pled allow him to get over the Turner factors, which is really more of an obstacle to relief rather than establishment of the right, then I think he would be able to prevail on qualified immunity.
Counsel, this is Judge Harris again. I just want to follow up, going back to sort of how your arguments fit together. So just assume for a minute, hypothetically, that there were qualified immunity on the damages claim under the free exercise clause. If that were true, and I understand this is hypothetical and you disagree, but if it were true that there were not going to be damages available under the free exercise claim, does that claim really matter in this case anymore? I mean, if you were, I guess, also assuming hypothetically that you were you were correct, that your RLUIPA claim is not moot. And so if that claim were going back to the district court, would it really matter one way or another whether the free exercise clause were going back, given that the standard is more generous for you under RLUIPA? I guess what I'm getting at is the thing you get out of your free exercise claim that you don't get out of RLUIPA is damages. But if there aren't damages anyway under the free exercise clause, does it still matter as a practical matter to your case?
Well, as a practical matter, Mr. Gentry's relief under the hypothetical that you're proposing would be provided by a favorable decision on the RLUIPA matter.
Okay.
However, I would just point out that, you know, one, there's an interest in progressing the law, in realizing these rights, and, you know, there are a number of cases dealing with this policy and previous policies under RLUIPA that, you know, do not apply clearly in the First Amendment context because they were just under RLUIPA. So I think there's a benefit to having a ruling on the merits on the First Amendment claim. And in addition, I think there's just, you know, just as a human, I think Mr. Gentry has an interest in having someone recognize that his rights were violated. So even if he would get the same injunction under RLUIPA, I still think that there would be value.
And you would also get the same acknowledgement that your rights have been violated, right? I mean, I absolutely understand what you're saying on behalf of your client, and I appreciate it, but at least in the hypothetical I'm setting up, that there will be an acknowledgement that rights were violated. It would just be under RLUIPA and not the free exercise clause, right?
I just, you know, speaking on the human aspect of it again, I think RLUIPA has, you know, our RLUIPA's nature is that it's asking, did the defendants affirmatively take enough steps to ensure that they were protecting rights to the maximum degree available? And the First Amendment test, I think, reduces to, did they have to do it, and did they do their best? And I think that's a slightly different question with slightly different implications. But yeah.
Thank you.
On the qualified immunity, isn't this overall landscape one where qualified immunity would have a particular applicability, because there are few areas of law which are more rapidly evolving than that of the First Amendment religious exercise rights of inmates. And if you look at it, you know, as we are bound to do, what the law was at the time that these various policies were operative, you have a huge number of cases at the time that this policy with regard to beards and beards at intake, saying that the governing policy, that the grooming policy was perfectly fine. And the policy, it seems to me that qualified immunity is particularly applicable when you are dealing with a constitutional policy that seems to be changing almost every fortnight. And it's very, very hard for people, whether they be in some sort of law enforcement activity or prison governance, it's very hard to keep track of this stuff, really. And they try and they hold classes on it, and they hold continuing education studies about how the law is changing and how can we adapt to it. And to take these rapidly shifting tides and say, well, no, we're going to string you up for damages in the middle of all this flux, it seems to me to go against the whole purpose of the qualified immunity in the first place.
Well, Your Honor, I understand that concern. However, I think, you know, in this case, you can fairly point to a few very clear benchmarks establishing that there was a First Amendment right to grow a beard, whether it was justified.
There's so much of the law that emphasizes that beards make routine searches slower, and that they make them less efficient, and that also that some of the having a beard or having an ID at intake, which is the most important thing, I think, to have that shaven ID at intake, because then you have a baseline. Whereas if there's someone bearded at intake, which is a very critical part of the whole process, then you lack that baseline and that basis of comparison. You don't have an idea. If there's a real serious incident and someone was taking it with, you have an individual who committed something with a beard, and he says, no, I didn't do it, then you could conceivably ask that person be shaven in the meantime to see if it complied with for purposes of comparison, to see who it was that the purposes of identification. It's just immeasurably helpful to have that initial beardless photograph. At least that's what the cases seem to say. And you know, you have Holt v. Hobbs, which is saying that there is a compelling interest, which has implications both for the free exercise claim and also for an equal protection claim. That's pretty strong language to say that you have a compelling interest in some sort of beard identity, because of the value that it has for the discovery of not only for identity but for the discovery of contraband. And it just seems to me the whole situation, together with the case law, really puts prison officials in a very rough place. Even as judges, we have a problem sometimes keeping up with how quickly the content of the law is changing. There's circuit court decisions that come out all the time. There's Supreme Court decisions that come out all the time. We're holding this case in abeyance for that other case and all the rest. Even from the bench, it becomes hard sometimes to keep abreast of everything that's going on. And how much harder must it be for prison officials to do the same thing? That's all I'm saying.
Yes, Your Honor, and I think that would be a real concern if Mr. Gentry's case relied on, 2 or 3 district court cases preceding the events. It would be unmanageable for VDOC to be up to breast on every possible development in the law. But I think you identified Holt v. Hobbs, which I think is on point here. As you noted, it recognized a compelling interest in safety and security and identification, but at the same time, it found that compelling interest was, that the policy in question was not the least restrictive means to accomplish it. And while the analysis is different under our LUPA and the First Amendment, I think that
Counsel, this Judge Richardson, I don't want to run out of time, and I have a question on RLUPA. You stated when your sort of introduction that your client had requested broad injunctive relief, and that sort of was part of the point that it wasn't moot here. When I look at the complaint in paragraph 99, I don't see broad injunctive relief, and so I want you to sort of help me understand how you get from transfer me or open up a new prison to sort of broad injunctive relief that you claim was requested here. Don't we have to look at what he actually requested and evaluate whether it is either available or whether that relief is moot, not some generic injunctive relief?
Yes, Your Honor, we do have to look at the complaints. However, as Williamson and Wall v. Wade recognized, we also have to construe a pro se complaint liberally. So first, may I finish answering the question?
Yeah, we'll give you some extra time.
Okay, thank you, Your Honors. So first, I think that liberally construing the complaint, given that Mr. Gentry was in the VHU at the time that he filed the complaint, asking for them to open up a hair unit on a lower security level, it incorporates a request to be able to maintain his beard without being in solitary confinement in the VHU. The second point is that paragraph 103 requests any additional relief that this court deems just, proper, and equitable. And, in Wall v. Wade and in Williamson, this court recognized that for a pro se complaint, that language, and actually that specific language, can be interpreted to seek all appropriate relief that's available, so long as it's based on the injury that's pled in the complaint.
Well, I'm concerned about advisory opinions here, and he's now free to wear his beard in Buckingham. He's not in segregation. He can practice his religion. He's past the intake stage. It seems to me he's, got all the relief he seeks. Now, what do you predicate your claim that it's not moot on? Is this the voluntary cessation of unlawful activity, or what?
That's correct, Your Honor. And to be clear, Mr. Gentry is not seeking injunctive relief relating to his intake shave, and only to the requirement that he live in solitary confinement if he wishes to practice his religion. And the reason that that's not moot is the voluntary cessation doctrine. If you look at defendant's brief, they explicitly say that you shouldn't tie their hands, reduce their discretion, and suggest that entering an injunction protecting Mr. Gentry's constitutional rights would somehow raise some federalism concern. Whether they currently plan to go back to the previous policy or not, they're explicitly signaling that they are able to and want to maintain the ability to.
But
at
realistically,
that point,
in light of the law now, which you say is clearly established and was even clearly established well before this, what possible reason or incentive would they have to reinstate the grooming policy and to sanction violations of it by sending someone to isolation or the VHU? I mean, is there any realistic chance that these folks are going to go back to an impermissible grooming policy, because the whole course of their grooming policy has generally been one, it's followed a trajectory of loosening restrictions. And I don't understand that why this is likely to recur. Why? What reason do you have to think? Do you think that they would go back?
Well, Your Honor,
Yes, they would be facing a slew of litigation and everything else.
Well, Your Honor, I mean, in Wall v. Wade and in Porter v. Clark, the courts did not really investigate the present future intentions of the defendants, but instead noted that they maintained the ability to go back. And in fact, noting that the frequent revisions of the policy suggested more than a mere possibility in Porter v. Clark.
But generally, when we are going to grant some kind of futuristic equitable relief, which an injunction is, we know that damages are retrospective, and injunctive relief is prospective, and isn't there a federalism component to this, which is that you don't just grant injunctive relief against state officials and state institutional managers just for the heck of it? I guess it was Lyons versus City of Los Angeles or something that is saying, is there, if you're going to grant injunctive relief against state officials, if a federal court is going to grant injunctive relief against state officials, there has to be some realistic or imminent danger that a legal violation is going to occur. And I put myself in the chair of a prison administrator and looking at the law as it is today and the change after 5 years, within a space of about 5 years, I would say to the people around me in the room, we'd have to be out of their mind to go back to our former grooming policy. We'd be tied up in litigation all day long. Isn't that the way? I mean, isn't that realistic in the real world? The fact that there's no restriction now, as long as the beards are hygienic, and that he can do what he wants. He's free to wear it, and I feel sort of silly enjoining something that is not likely to occur.
Well, Your Honor, practically speaking, and I understand this is not responsive to all of your concerns, but practically speaking, if the injunction were entered and VDOC never went back, there would be no harm. I understand the concern about advisory opinions. However, on the ground, that would not harm them if they never wanted to go back.
I think my broader concern is the federalism point, is a structural point. But then there's another thing about the voluntary cessation doctrine. Obviously, you can't moot a case just through voluntary cessation of unlawful activities, but you have to ask why that voluntary cessation exception to mootness, why it exists, and what it exists to do is to avoid gamesmanship of somebody who looks like they're going to lose and then voluntarily ceases a policy that the court is about to rule unlawful, and then once the suit is dismissed, it goes back to the former wayward ways. But I don't see that the voluntary cessation such as it is, or the change such as it is a part of some strategic plan or as a part of some sort of games playing on the part of state officials. It seems to me they were just trying to do their best to keep up with the law. If I thought they were playing games and just sort of acting really strategically, then that would be one thing. Do you have any reason to believe that there's something that the voluntary cessation represents some sort of manipulative activity or shenanigans? Is there some reason we should believe that?
Well, Your Honor, this court's cases don't require evidence of bad faith on the part of the defendant in order for the voluntary cessation doctrine to apply. Wall v. Wade itself found no specific evidence that they were intending to, that it was, that pure gamesmanship that you're suggesting. But it did note that, that complaint, that the policy change there was issued after the complaint was filed in that case, and that it was in the midst of another separate lawsuit filed by another inmate challenging the same policy. It found that voluntary cessation doctrine applied in that factual situation, which is precisely what happened here with Mr. Gentry and Greenhill. The policy was changed in the midst of litigation challenging it, and there's simply, it's showing that the voluntary cessation doctrine doesn't apply is the defendant's burden, and there just simply isn't a requirement to prove bad faith on the part of the government.
Going back to the federalism point I was raising, if you take the view of voluntary cessation that I'm doing here for purposes of argument, doesn't this give you want to give state officials an incentive to change their policies and to move toward more progressive policies in the area of religious exercise. And part of the incentive to move toward a more progressive governance structure in the penal context is they might be free of the possibility of an injunction. They might get that sword off their neck. But if we say, oh, well, voluntary cessation, that doesn't mean anything, and we're going to slam an injunction on you anyway, then that begins to disincentivize state officials from, frankly, making changes in the exercise of religious exercise that I think we would all want to see occur. We want to make it hospitable for state institutional governance to move in a more respectful direction with respect to rights. And I know just in the real world, part of what incentivizes them is they're not going to get slammed with an injunctive decree, and they make the adjustment. but you see what I'm saying is if you ask us to apply the voluntary cessation exception to mootness, aren't you arguing you might get something in the short run, but in the long run, aren't you arguing against the larger body of prisoners who would want the voluntary cessation?
Well, Your Honor, I don't think so. I think that applying voluntary cessation doctrine in this case does not discourage development in the law. You've suggested that there's kind of a one-way transition towards more progressive respect for religious freedoms, and that it would be very positive if that were the case. However, applying voluntary cessation here does not punish them for later moving to a better policy. It simply recognizes that they didn't move to the better policy earlier. Holt v. Hobbs was decided in 2015 and essentially recognized the current VDOC policy in rough contours as being at least less restrictive than was in place at the time. It took 4 years after Holt v. Hobbs for VDOC, 4 years and several lawsuits challenging the existing policy for VDOC to change its policy to one that had been sanctioned as less restrictive. I don't necessarily believe that holding VDOC responsible for violating constitutional rights in 2016, despite the fact that they have changed their policy since, encourages them not to change their policy later.
Well, I'll be willing to bet you a chocolate milkshake that the VDOC and Buckingham in particular is not about to go back to what they had 6 years ago. But at any rate, you've got some rebuttal time, and I thank you very much for your argument, and I really do appreciate it. And I'm going to ask, before we let go of you, I'm going to ask Judge Harris if she has some questions for you.
No, that's okay. Thank you.
Judge Richardson?
I'm good. Thank you.
Okay, let's hear from the other side.
Good afternoon, Your Honors. May it please the Court, Laura Cahill on behalf of the appellees. I would like to start my argument where Judge Wilkinson left off regarding the mootness of injunctive relief here. And Judge Wilkinson recognized today, the landscape of free exercise rights of inmates. There's a very few other areas of law that are expanding as rapidly as they are. And the Department of Corrections grooming policies has gone in that exact same trend. This is not a case where voluntary cessation is appropriate to invoke as an exception to mootness.
Counsel, I did struggle with this. There have been so many changes in the policy in recent years. They're not all in one direction. Unless I misunderstood, in 2019, the intake policy went back to sort of forced compliance without religious exceptions. So they go both ways. And doesn't the current policy itself sort of call for periodic review? It's not even purporting to be the last word. So I think it is. I agree with you that if we sort of look at the law as a whole, there seems to be something of a trajectory, but that's not exactly the question. I think the question coming out of our cases is whether it is absolutely clear that the policy won't change again. And so I guess I want to give you a chance to address my concern, which is that this has been a bit of a moving target. There have been changes going both ways. The policy we have in front of us does not purport to be the end of the matter. How can we be so sure there's not going to be a change?
Yes, Your Honor. First, I respectfully disagree with your assessment of the policies not being a progression. The 2019 policy regarding intake, well, yes, it does allow for use of reasonable force if an offender refuses to comply with the intake procedure in order to obtain that initial photograph.
Right, and in 2016,
pointed out
please tell me if I'm wrong factually, but I thought that in December 2016, the intake policy allowed for a religious exemption for forced shaving. And I'm not trying to talk about the substance of those policies or their legalities, just to make kind of a descriptive point that here's one case where the policy became sort of less generous toward religious objections over time in recent years. Is that not right?
I understand what you're saying, Your Honor, but you have to look at it in the entire policy. In the 2016 policy that changed to allow religious exemptions or objections was when they were allowed to then be transferred directly to the VHU in this small housing unit. So there was only 30 offenders, maybe 40 offenders, who maybe wouldn't have the dual ID photograph. With the 2019 policy, we're talking about 25,000 offenders, and so the need for the dual photograph, the clean-shaven initial baseline, is essential. That is what allows the department to make the change that it did in 2019, expanding, the ability to, have longer hair and beards at all facilities in DOC. So, while if you look at it in a sort of microscopic way, of they had it then and they don't have it now, but you have to look at it in the context of what the reasoning behind it is. That change in 2019 allowed for this much more expansive or less restrictive policy.
Counsel, can I ask two questions on Wall versus Wade? I had read Wall versus Wade to sort of rightly or wrongly preclude us from doing this, is it likely analysis, but instead to require sort of record evidence that it would not be reinstated. And so can you address how, after Wall versus Wade, we can make the decision that the voluntary cessation doctrine doesn't apply without record evidence? And then the second question I've got, which is maybe related, is whether you agree with your colleague that Wall versus Wade tells us that we should read paragraph 103 of the complaint to encompass a broad demand for injunctive relief as opposed to the much narrower demand that's made in paragraph 99.
Yes, Your Honor. First, I'll just touch on that last point. I do not interpret 103 of the complaint to be the same as the situation in Wall. In Wall, there was actually no specific claim for injunctive relief, and that was the only claim for injunctive relief, sort of those broad statements. Here, he has very specific requests, so we don't have to look further to construe the intent of the pro se plaintiff. It's very clear. He wrote it. It's different than in Wall v. Wade, where he only asked for just proper and equitable relief. So I think it's different. Back to your first question in terms of Wall v. Wade on distinguishing that of whether or not you do an inquiry of likelihood, if I'm rephrasing that correctly. I think there's several different distinctions here. Wall v. Wade, the change in policy occurred after the filing of the complaint and before the district court had ruled on the dispositive motions. In this case, the department had already obtained a favorable result from the district court in 2019 before changing its complaint. So you don't have that same aspect that you could potentially infer that there's a change in policy in order to attempt to achieve a favorable result.
But Wall versus Wade says that defendants have failed to put forth a single piece of evidence, right? Nothing in the record suggests that they're barred or considers itself barred. And I guess what your argument is that didn't impose a requirement of some record evidence, that we should sort of read that part as dicta?
No, Your Honor, I would say that, if there is a complete absence of any fact that could be construed as gamesmanship or, directly targeted at the purpose of the voluntary cessation doctrine, then doing an inquiry of whether or not defendants had put forward other evidence of that is different. I think in Wall v. Wade, the court had construed several different things to, not reassure them that the department wouldn't change the policy back. Part of that analysis was the fact that...
Counsel, one thing, we're concentrating a great deal on Wall v. Wade, but there's a preceding case that one case can't overrule another, and that case is Nkuma, I guess, v. Osment. It's a 2007 Fourth Circuit precedent, and the discussion there in that case is that the voluntary cessation doctrine does not apply, quote, where there's no reasonable expectation that the wrong will be repeated. Now, in the Nkuma case, they look at the reasonable expectation that the wrong will be repeated, and that's a call. But doesn't that precedent have to figure into this whole calculus?
Yes, Your Honor, and I believe they could be read together. That
you always try to harmonize precedents, but I mean, I do think the Nkuma says that doesn't say that there has to be it has to be beyond a reasonable doubt, and then some, that it will never ever be repeated. It talks in terms of reasonable expectations, and I don't understand that Wall v. Wade really contradicts that, and I think they need to be read in pari materia. And I'm wondering if if a reasonable expectation standard is one that could come out of a pari materia reading of those two cases.
Your Honor, I think that you could absolutely read a reasonable expectation standard to come out of those 2-3 cases, but I would also argue that in this particular case, we're well beyond that. There is no plausible, as Your Honor stated, there's no possible plausible reason to return to the old policy. So for very many reasons, there is more than just not a somewhat unlikelihood or reasonable unlikelihood to return. I think that there is no likelihood to return to the policy as it would exist in 2016. First of all, there has been a national trend in terms of post-Holt to now in the field of corrections and in the courts of moving towards less restrictions on grooming policies in corrections. The Department of Corrections here in Virginia now has one of the most progressive policies and has, I would argue, moved.
So are you authorized?
Direction.
Are you authorized to speak for the VDOC and saying that this is just not going to happen?
Your Honor, I can represent today on behalf of DOC that there is no, they will not return to the 2016 policy as it existed.
Okay. Well, you're making a statement now in open court Your
Honor, and I have permission of my client to do so.
I thought you might, and that is important to me because I think there's a commitment there in the statement that you just made. And there's one other point that because I thought Judge Harris raised the interesting point when she said over the past 4 years the changes have sort of gone both ways, and it hasn't been just an uninterrupted one direction trajectory. And I wonder what you would say with regard to the question that she raised about the case both directions, about the policy going in both directions.
Yes, Your Honor. I would argue, respectfully, I would disagree with her that I believe that it goes in one single direction. That, well, if you look at one change in isolation, such as the intake policy or what they do on intake, you could say, well, they allowed for a religious, exemption before, and now they're not. Well, you have to look at that in the greater context, because the reason that they have to now require it is because they don't have a secure violators unit where you can house offenders who do not have that dual photograph, do not have that baseline, as Your Honor pointed out. And so by expanding, the grooming policy to not restrict all the DOC inmates, 25,000 inmates, the baseline photograph is essential to be able to provide for this greater accommodation or less restrictive accommodation. And so,
thank you, counsel. This is Judge Harris. I understand your answer. Thank you. Can I ask you about the equal protection claim, which it looks like the district court dismissed on the pleadings for failure to state the claim? And it looked to me as though the first element, that religious objectors were treated differently than non-religious objectors, was alleged. And I know your brief focuses on the failure to allege the second element, the discriminatory intent or motive. But given that this is a pro se complaint on page 20 of the joint appendix, where it says that, paragraph 84, David Robinson is fully aware that Muslims and Rastafarians grow hair, but authorize the use of force to, I think it's to such inmates, or to cut inmates' hair to punish them. That seems like an allegation, pretty clear allegation of discriminatory intent. So what do you want us to do with that claim? It looks to me, at least, as though we need to send that back. But tell me why I'm wrong.
Your Honor, to the extent that he is making a facial challenge to the policy, because
I'm talking about his challenge of discriminatory enforcement, that it is being applied to religious objectors, and in particular to Muslim religious objectors, by David Robinson to punish them.
I'm sorry. I just want to turn to that part.
Your Honor, I don't think that there's a name. There's no name of who's involved. There's no allegation that it's done for a bad reason. And I'm looking at the complaint, and again, it's a pro se litigant, and you've got your name, and you've got the allegation. They're doing it to Muslims to punish them. I don't know what else you would ask a pro se litigant to say.
I would agree, Your Honor, if you were reading that particular claim to state a, I guess, as applied challenge. Dave Robinson, he does allege is his official capacity as the person who is responsible for the policy. He does not work at Nottoway. There is no allegation that he told any authorized the use of force
to punish Muslims. I'm sure you think that this claim will not prove out, but I don't see how we can dismiss it on the pleadings, which is what the district court did.
Your Honor, if the court does not agree with my first argument, that I don't believe that he states a claim that there's differential treatment.
I mean, did you address paragraph 84?
That the court should remand.
Counsel, I didn't notice that you even addressed this paragraph of the complaint in your brief. Instead, you said there's no allegation of any discriminatory intent. There's no name attached to these allegations, but it's right here. And I'm sort of left a bit adrift on what I should do with your argument on this point.
I understand, Your Honor. And in reading these pro se complaints, he brought many other arguments that are not on appeal at this time. And so parsing those out and which facts apply to which could be difficult for the district court.
So I thought the argument here in part was, and maybe I'm misreading. I thought in part the argument here was that he didn't allege that similarly situated people were treated differently. That is, either non-Muslim or I thought it was sort of more non-religious folks were not treated that way. Is that the argument? Are you not really making that argument? You're really focused on the sort of discriminatory intent piece of the argument?
My argument would be twofold. That first of all, the pleading fails under the first element in terms of alleging applied that has actually been applied discriminatorily. He really only alleges that some people had their hair cut at intake, and those people that he knows are religious. But he does not say that the people who did not have to forcibly have their hair cut at intake objected. If you don't object, they're not going to forcibly cut your hair. That is only if someone doesn't voluntarily come into compliance.
It looked to me like he was saying that none of the Virgin Islands inmates had their hair cut, but they did forcibly cut the hair just of the people who grew their hair religiously. I guess I'm not sure what I'm missing here.
Do we know? I guess do we know whether the Virgin Island inmates had hair that was out of compliance? I mean,
Your Honor, this isn't in the record, but the Virgin Island inmates are actually part of an interstate compact that are transferred directly from the Virgin Islands to Wallens Ridge at that time per a contract between the Virgin Islands and the Department of Corrections. I would argue that if the court has questions about the pleading standard in this, that the best outcome would be to sort of remand for further development on the record.
What
if we're talking about as applied standard.
We're so focused on qualified immunity in the Fourth Amendment area and the First Amendment area. What applicability, if any, does qualified immunity have with respect to the equal protection claim, and does it matter whether the claim is one of whether the challenge is a facial challenge or an as-applied challenge? What do you say as to that?
Your Honor, it does matter. The equal protection analysis would only really encompass a qualified immunity argument if it was a facial challenge to the policy. And I think that the statement that Judge Harris pointed out by Dave Robinson could be construed, or the court may have construed, as a facial challenge to the policy. Under those circumstances, I believe that absolutely this policy is facially neutral. And even if the court were to find otherwise, that they would be entitled to qualified immunity.
I want to make sure I understand this. So you think an allegation that they're using forced haircuts to punish Muslims is a facially neutral policy? No? What am I missing?
To the extent that he is arguing, that counsel argues in his reply brief, that it is not facially neutral because of a disparate impact. And I believe that if you read the pro se complainant statements in conjunction, that one with other, with the sentences around them, that he, is intending to say that that there is a burden on religious offenders.
Okay, but so I actually think we agree on this, and I just want to make sure. If I read the complaint as alleging, first, that they only cut the hair of religious objectors, and second, that they do that to punish Muslims, nobody thinks there's qualified immunity on that kind of a discriminatory enforcement claim, right? You're saying there's qualified immunity if the claim is different, just that overall there's a policy of cutting hair, they do it to everyone, and it has a disparate impact on religious observers. There might be qualified immunity as to that claim, but a claim that a policy is being discriminatorily enforced only against religious objectors in order to punish Muslims, that would not get qualified immunity.
Correct, Your Honor.
Okay.
If Your Honor has any other questions about...
I'm wondering here, we have the pleading standards of Iqbal Twombly, which requires that a complaint allege a plausible claim and not just something that is within the realm of possibility. And does Iqbal and Twombly require something more here than just a sort of flat conclusion, or just something more than saying Muslims have been discriminated against? You don't obviously expect the kind of development of the claim on the pleadings that you would on a summary judgment record, but even in a pro se situation, wouldn't Twombly recall and Iqbal, wouldn't they suggest that there be some factual material or some development of it beyond a flat conclusion that gave us some underpinning or reason to believe that there might have been some kind of discrimination afoot? And I guess my problem is awfully threadbare in terms of what is being said. Is this a facial challenge or is it an applied challenge? And if it's one or the other, what is the factual underpinning of it all? And I of course you give a certain latitude to a pro se plaintiff, that's only right, but at the same time, it's not unfair to require something more in the way of specificity and factual development in the course of a complaint than was provided here. This one, with respect to the equal protection claim, seems skimpy. So how do those pleading standards bear upon the issue?
Yes, Your Honor. I think that these are what under Iqbal would be considered conclusory allegations that likely do not fall in the realm of plausibility. I would also like to point Your Honors in the direction of the affidavit that was filed. While it wasn't addressed by the court, it is part of this record on JA 71 by Dave Robinson, explaining that offenders are treated alike during intake regard to compliance with the grooming standards, irrespective of their religious affiliation. And so that read in conjunction with the policy itself clearly being facial, I think, may if the court were to look at this from not just a pleading standard, but defeat his claim on a summary judgment standard.
Okay, at this point, counsel, I think we've both sides have chewed the bone. I'm going to ask both of my colleagues, each of my colleagues, if they have further questions. Judge Harris, do you have some further questions you would like to ask?
No, thank you.
Judge Richardson?
Sorry, I do not.
All right, thank you very much. And then let's hear from the appellant here on rebuttal, okay?
Thank you, Your Honors. I just have a few points I'd like to clear up. One, regarding that statement from Defendant Robinson's affidavit, that speaks specifically to what the policy states and not to what they actually do, given that this is an as-applied challenge. Describing that the policy does not differentiate between religious and non-religious individuals does not do that amount of work. Regarding Judge Wilkinson's question about Iqbal, I would just refer the court to Williams v. Hansen at Williams v. Hansen at 584 to 585. It quotes Arlington Heights as noting that in the context of an equal protection claim, in delving in the minds of state officials, the court may look to such circumstantial and direct evidence of intent as may be available. Given that, I think everyone agrees that Mr. Gentry alleged that the policy was applied against religious individuals and not against non-religious individuals. I think the...
Right, but what backup is there for this?
Well, Your Honor, there hasn't been discovery. Mr. Gentry wasn't permitted to go to discovery on this claim.
This is the point of Iqbal Twombly, that you could just give us something. I mean, I think Judge Harris is correct that you can't have, if you're overtly discriminatory, you can't have qualified immunity on something like that, because it's clear you're not supposed to be discriminating against any religious affiliation. But where is it? Let's say, okay, let's say it's an as-applied challenge. An as-applied challenge would require some factual backup under Iqbal Twombly, more so than a purely facial challenge. And where's the backup?
Well, Your Honor, among others, I think Judge Harris identified one allegation relating to intent. I'd also point the court to paragraph 12 of the complaint, where he says that they were just trying to humiliate him if they were going to put him in solitary anyway. And he repeats that allegation that they forcibly shaved him at intake just in order to humiliate him several times.
Can I go back to the earlier question? What is the site in the complaint that I'm to draw out that there are similarly situated people, in other words, people who had long hair, who were forcibly shaved or not forcibly shaved, even though they would have been under the policy? What's the best evidence? And I don't mean evidence, I mean the best allegation that you point to there?
Well, Your Honor, I think, I would note that the district court also recognized the nature of Mr. Gentry's allegations here. He does allege that the Virgin Island inmates who are in the VHU did not have their hair cut during initial intake. He alleges that...
And from that, on the Virgin Islands, what you're asking us to do, maybe legitimately, right? I'm not fighting you on it. I just want to make sure I understand that we should infer or liberally construe that allegation to say that they were from the Virgin Islands and they had long hair and they were not forcibly shaved, or their hair was not cut. Right? The part of that that's not included is that they fell within the policy and should have had their hair cut. Is that, that might be a fair inference from what he's saying, but I'm just trying to understand. That's the argument you're making, is that implicit in the statement he makes is that the Virgin Island inmates had long hair.
That's correct, Your Honor. I think that's the only way to read that allegation fairly.
All right, Judge Harris, I see the bell's rung. Judge Harris, do you have some further questions?
No, thank you.
Judge Richardson?
I don't. Thank you very much.
Okay, want to thank you. Want to thank you both for your arguments. We appreciate it very much, and we will take a brief recess. And I'll ask the courtroom deputy to call us back into session as early as practical.
The court will take The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right, counsel for Mr. Haas, would you like to commence your argument? Your name is what now again?
It's William Dinkin.
All right, we're happy to have you here, and why don't you begin your argument?
Thank you. Good morning, Your Honors, and may it please the Court. As I just indicated, my name is William Dinkin, and I represent the appellant Richard Todd Haas. Broadly, this appeal concerns three issues. The first issue concerns two search warrants that were upheld by the district court despite the case agent's intentional omission from the affidavit of critical and damaging information about the informant's credibility. The second issue concerns the lack of evidence showing that Mr. Haas took a substantial step in furtherance of sex trafficking to support the attempt conviction in this case. And third, we've raised two sentencing issues. The first concerns the district court's what we believe to be erroneous application of a guidelines enhancement for attempting to traffic two fictitious children under guideline section 2G 2.1 B1A, where contrary to the application notes, the person that was representing the age of the minors was not a law enforcement officer. The second sentencing issue that we raise involves the district court's application of a 5-level enhancement under the guidelines section 4B 1.5, despite what we believe to be a significant ambiguity regarding whether that enhancement should apply when the primary guidelines provision that was calculated was not a covered sex crime. And if the court doesn't have an objection, I'd like to start by addressing the sentencing issues first, and in particular the guideline enhancement imposed under guideline section 2G 2.1 B1 for the fictitious minors. The facts in this case disclose that it was the confidential witness, which I'm going to refer to as CW rather than her actual name or the term confidential witness. That's how she was addressed throughout the case below and in the briefing in this case. So in this case, CW, who is not a law enforcement officer, represented to Mr. Haas that the ages of the fictional children were 8 and 12. However, plain reading of application note 1 discloses that in order for the enhancement for attempted trafficking of a fictional minor to apply under that provision 2G 2.1 B1, the age representation has to be made by law enforcement. So note 1 states has 3 different subsections. Section A defines a minor, and so note 1 is the definition of a minor. And it indicates that a minor is defined as A, an individual who has not attained the age of 18. We don't have that in this case. B, an individual fictitious or not, who a law enforcement officer represented to a participant, 1, had not attained the age of 18, and 2, could be provided for the purposes of engaging in sexually explicit conduct. Or C, an undercover law enforcement officer who represented to the participant that the officer had not attained the age of 18. The district court in this case applied the enhancement under subsection A, reasoning that an attempt crime turned on the understanding of the defendant, what he believed, that the individual had not attained the age of 18. That was erroneous. I think a straight reading of the application indicates that.
I mean, it seems to me that the whole purpose of the 2G 2.1 enhancement is to make sure that the participant, the defendant in this case, is clear that the sexual molestation and the sexual abuse is of children and is not under any kind of confusion. They're just, how could there be the slightest doubt in the defendant's mind that his attempted solicitations and his molestations were of minors, way, in his initial molestation was of an 11-year-old, which is nowhere close to being an adult. And the whole emphasis or the whole reason of the defendant's relationship to the confidential witness was with one purpose in mind, and that is to procure underage girls for himself, to either produce child pornography or for himself to personally molest. And it is true that the law enforcement officers did not personally tell this Mr. Haas that they were minors, but on the other hand, CW was very explicit and clear in her representations that these were minors, because that was the whole reason for their relationship, was to procure minors to molest. And I don't know why the agency principles would not apply, because CW was in an agency relationship with the law enforcement officers, and it does seem to me that if the purpose of the enhancement is to have some awareness and not apply the enhancement where there's some reasonable doubt. But here, whether you take the 11-year-old molestation or the procurement efforts, in neither one of those cases could there be any doubt. And, it seemed to me where this Seventh Circuit opinion in United States v. Turner says, the common sense has to come in here somewhere, and then they use the Seventh Circuit used the phrase that the courts must, quote, not read the guidelines in a way that makes the sentencing commission look foolish. And we would make the sentencing commission look foolish, would we not, if we said, the sentencing enhancement applies when the officers themselves offer a fictitious minor to an individual, but no, it doesn't apply when the same identical offer is made by a witness not only cooperating with, but directed by law enforcement to do. And that would just, it seems nonsensical to not to do that, because there couldn't be, what happened here is very depressing, and you don't want to be unfair to anybody, but how could there be any doubt to Mr. Haas that he was attempting and committing sexual abuse of very young children? I don't get it.
Your Honor, so these cases are often made through the use of law enforcement, as the court knows. And when law enforcement officers are either representing themselves to be under the age of 18 or when they are representing that they have someone available for the participant, the defendant, who's under the age of 18, they also are crystal clear about the age of the fictitious individual that they're offering. We have to presume that the Guidelines Commission, when they wrote this, understood that these cases, obviously they did because they are referencing law enforcement. They know that how these cases are often made. And they clarified that an individual, fictitious or not, which would go to the attempt. If it's fictitious, it's an attempt because they can't have a completed crime if there's no actual child. But they didn't create a separate category, which they could have, to say that that any individual, fictitious or represented a participant, fictitious or not, had not attained the age of 18.
Counsel, this is Judge Richardson. Can I interject here?
Oh, yes, sir.
If we were to agree with you on this issue, and it showed back up in the district court, you would agree, I assume, that the district court could make the decision to vary upward based on the purpose of this guideline provision, even if it did not technically apply. That would be, at least theoretically, within the court's power to do. Whether, I know you don't think it's a good idea, but that would be within the court's power to do. Fair?
That I agree, and the question then becomes whether, if it is error, is it harmless or not? I don't know how this would affect the district court in its analysis. It reduces. What happens is that each child represented becomes a separate. They call it a pseudo count within the guidelines, and it reduces the guidelines for both of those because one was represented to be 8, and that's a 4 levels lower, and then one of them was represented to be I think 12, and that would reduce it by another 2 points.
Counsel, is it your position that would actually change the guidelines calculation? Because I tried to do it and I had some trouble because it's complicated, but I thought the guidelines calculation would be the same. It would still be 43.
Right. It is super complicated. Here's what I've come up with, and this is I'm looking at Joint Appendix page 1081 and 1082.
Yeah, that's what I was too.
And I spent a long time, in fact, last night going through this because it is complicated. I think the first count, or the first minor, goes from 33 to 29. That's on line 42 on page 1081. I don't know if you have it in front of you, but I'll
I do, but can I jump you to the end? Because what I got was that the number would go down, but it would still be over 43.
Correct. I reached the same.
Come down to 43, right? So don't you end up in the same place?
So yes, yeah,
okay.
I reached the same conclusion after doing this, trying to come up with a different conclusion last night. But yes, you come up with 43 because it would be lower. It goes down the total, but because of line 56, everything reverts down to 43.
Okay. But this one by itself actually doesn't even change the guidelines range.
No, but I don't know how, and I think we'd have to speculate as to how even the internal calculations changing and coming out lower before the final line lowers it may have affected the sentencing judge. But yes, you're right. If this one alone would not change the guidelines. The second sentencing issue, and I've only got about a minute left.
Oh, you know what? I'm sorry because we've got so many questions, but I want to just go back quickly to this one. And the question of whether we can treat the CW as a kind of designated law enforcement officer. Does it matter to your argument that she made up these fictitious Baltimore girls on her own before she ever talked to the FBI about the case? That she was not under the direction of the FBI when she first represented these fictitious people as being underage?
Well, yes, of course, because that defeats the agency argument to some degree. She's not acting at the direction or as an agent of law enforcement. She's doing that on her own. And so, in essence, law enforcement comes in and adopts her position moving forward. But even under the agency argument, it requires that this court disregard the use of the term fictitious in both subsections B, what's only in subsection B, but also C anticipates that the age is fictitious. The government's agency argument also.
No, go ahead. You answer the court.
Thank you, Judge. The government, in support of its agency argument, points to other provisions of the law, other statutes, and I think, in fact, in one other place in the guidelines unrelated to this, to say that there are times when a government official is viewed broader to include people acting as an agent. But really what that points out, or points up, is that Congress, when they're writing a statute, and the Sentencing Commission, when they're writing a guideline, they know the consequences of their words and that they pick them carefully, and they didn't use the word agent here, and we have to give that some meaning. They didn't put it in there.
But they did use the word fictitious.
They did, and that's why I think it's important that they knew to use the word fictitious, but also did not say a law enforcement officer or one acting at the direction of a law enforcement officer. So
I guess my point is, by using the word fictitious, that sort of weakens your argument rather than strengthens it. But I guess this is one of these situations where maybe a little deference. I know you want to make it as a pure matter of law, but I'm not sure that a little deference isn't due to the district court, because again, just when you're at sentencing and you're applying the guidelines, the common sense of it has to enter in somewhere, and the purpose of it is to make sure that somebody who's attempting sex trafficking of children is not in the dark about their ages, and to make sure that yes, he knows that they are minors, and it's crystal clear what he knows here. And it just seems odd to say that, well, the sentencing enhancement applies when the officers themselves offer a fictitious minor to an individual, but oh no, absolutely cannot apply when the very same offer of minors for sexual molestation is made by an agent of law enforcement or a witness cooperating with and directed by law enforcement. That it just, seems an illogical result in terms of what the Sentencing Commission was after, which was to apply the enhancement when there's an awareness, either from law enforcement or its agent, under the direction of law enforcement, under that direction, to make it clear that these are minors involved. And as I understand it, the cooperating witness it communicated to her in very clear terms that she was to represent to Mr. Haas that these young girls were minors. That seems to me to be the common sense of it, and what the commission was aiming to get at.
Right, Judge. I suppose all I could say in response, you're right. It is crystal clear in the record that what was represented to Mr. Haas is that these were minors. And I would end on the note that two circuits, at least, who have addressed the definition of minor for the application of the enhancement have come down differently. United States versus Fulford in the 11th Circuit and United States versus Vasquez in the 5th Circuit both concluded differently. And in the words of Fulford, they said, quote, where the defendant is not dealing with a law enforcement officer, the enhancement applies only where the minor actually is a true, real, live, sure enough minor. And so, common sense or not, they were looking at the guidelines that were in front of them, how they were written, and applied them that way. And that's what I would ask.
I would say one thing to you, and that is that you've made all these different arguments in your brief, and the fact that you haven't been able to cover all of them, that doesn't waive them in any sense. You still, of course, have preserved all of those, and you've also reserved some time for rebuttal. So,
yes, sir.
If let me see once again if my co-panelists have any questions of you. Judge Harris, do you have any questions?
If I do, I can save them for rebuttal.
Okay, fine. Judge Richardson?
No, thank you.
Okay. We thank you. Now let's hear from the appellee.
Good morning, Your Honors. My name is Heather Mansfield, as I previously said, and I represent the United States in this case. After a 3-day jury trial, the defendant in this case was convicted of 3 counts relating to his receipt and possession of child pornography and 1 count of attempted sex trafficking of minors. And he was sentenced to a guideline sentence of life imprisonment. And this court should affirm the defendant's conviction and sentence because the district court committed no legal error in its rulings in this case. And so I will start as well where the defendant did, which is with the sentencing issues in this case. So turning to the first issue raised by Mr. Haas, that the guideline enhancement under 2B2.1B1A does not apply because of the definition of minor. I think we set out our position in our brief very clearly that the government at sentencing took the position with the district court that agency of principles should apply in this case based on a common sense reading of the guideline. And especially in this case, I would point to the factual record here and the record at trial that although that first meeting between CW, the confidential witness, and Mr. Haas was not done at the direction of law enforcement, that was in her capacity as an escort, she subsequently, after that meeting, when Mr. Haas raised the issue of getting children to use to produce child pornography for profit, she subsequently went to law enforcement, who then directed her to continue in this ruse that she had begun and to continue gathering information and seeking to offer these children, an 8- and a 12-year-old, to him for the purposes of producing child pornography.
Okay, so Counsel, this is Judge Harris. I think we're agreeing. I just want to make sure that I do understand the record right. So these fictitious minors were first represented by the confidential witness to the defendant as not yet 18 before she was an agent of law enforcement. But sort of retroactively, that comes in because she was later designated as an agent of law enforcement. Is that how this works?
Yes, Your Honor, that is a factual record in this case. They were initially represented by her to Mr. Haas prior to her reporting to law enforcement, and then law enforcement ratified that, and in fact then did begin directing her to continue in these interactions with Mr. Haas. And I think very clearly then throughout the rest of this, she's ultimately.
What do you make? I mean, the guidelines enhancement does say who a law enforcement officer represented to a participant had not yet. So, how is your reading of that that those key words, a law enforcement officer represented. Why do you think that allows for the application of agency principles?
Your Honor, we
does
believe
that language allow for the application of agency principles? It's clear that you have a very, very strong argument in terms of the common sense of it all, and the purpose of the enhancement is absolutely plain, and it was absolutely satisfied here. And so the one thing that I would appreciate your addressing is just how that word law enforcement, the way the Seventh Circuit interpreted it, how that language permits the application of agency principles.
Yes, Your Honor. I believe because agency principles are recognized in other places in the guidelines, but as well as specifically as applied to law enforcement, other places in the law where law enforcement directs private individuals to act on their behalf. And indeed, as this court is aware, certainly there can be Fourth Amendment violations when an individual is acting at the behest of law enforcement to engage with a defendant. And I don't want to belabor the point, but I think taking those principles and where they appear in other places in the law does apply seamlessly here where law enforcement is referenced. And to go again back to common sense, that it simply would look foolish if the agent had been the undercover CW and represented this exact same scenario to Mr. Haas, but because it was brought to them by a cooperating witness who they then directed to do so, this enhancement doesn't apply.
Counselor,
and then I would also just go to the point.
Counselor, this is Judge Harris. Sorry, it's so hard to signal on a phone.
Yes.
I mean, just as a matter of common sense, it doesn't strike me as that absurd that the Sentencing Commission might want to sort of authorize actual law enforcement officers to sort of engage in these sting operations without sort of putting its imprimatur on a bunch of other people who work loosely with the police running around and trying to entrap people into fake children pornography rings. It's not that crazy to me to think that the Commission might have picked its words with care. And so I want to ask you, what is the best, you alluded to other areas of the law where we read agency principles into this. Is there just a particular statute you can point me to or a guideline where the text is law enforcement official, but that has been construed to mean, in addition to law enforcement officials, also people working with them?
In the guidelines, Your Honor, there is no, we were unable to find any specific case as to that effect where it did not say agency. We pointed, I know in our brief, to the definition of public official, but that definition does say an individual working on behalf.
Right. That seems like it cuts the other way, that when they mean, and also people working with the officials, they say that.
Yes, I think as to that, Your Honor, I understand your point. I do think that the Fourth Amendment case law on agents of law enforcement does
but nothing
that
construes, but that's not really construing text in the same way. Like, is there anything that looks at the phrase law enforcement official as it appears in sort of a comparable guideline or statute and says that language includes people working with law enforcement?
No, Your Honor, I do not believe so.
Okay. And
I think in this instance, I would go back to the point that Judge Harris also made during the appellant's argument that on this particular guideline point, of course, any error that was made by the district court does not affect the guidelines in this case. It would simply put them back to 43. We would lose the grouping enhancement under Chapter 3, which again is a guideline range of life. And I do think we can read that as to be a harmless error in this case when a motion for a variance was made in the district court, and the district court considered that and denied it, finding that the appropriate sentence in this case was a sentence of life imprisonment.
Can we do that since you didn't argue harmless error? I mean, if you made that argument in your briefs, I'm with you, but in your view, can we and should we do that when the government did not allege harmless error?
Well, we did not argue that in our brief, Your Honor. I think that, based on the questions and the arguments made today, I do think this court could look at that in this case, or, of course, simply, if the court disagrees with the government, remand it for a resentencing, in which case it would not affect the guidelines. But we did not, I will make clear to the court, we did not make that argument in our brief as it was brought up today by Judge Harris.
Can I ask you about the other guidelines provision?
Yes.
I don't want to cut my colleagues off if they have more questions on the first one, but I am so confused by this 4B151, and it seems like the government was confused too, right? There were two different positions taken before the district court. So what is your understanding of how this applies in a case like this one where there are two offenses of conviction and one of them is covered, but one of them is excluded?
So, yes, Your Honor. The government's position on this and our understanding, reading 4B1.5, we'll start first with the sentencing guidelines and their instructions as to how we calculate sentences. This, of course, is to move through the chapters sequentially. So starting with our guidelines calculations for each offense under Chapter 2, then moving to Chapter 3 to determine how we decide which of those to use and which, if any, grouping enhancements should occur, and then moving to Chapter 4 to see if any additional enhancements. And so in this case, going to 4B 1.5b, which reads, in any case in which the defendant's instant offense of conviction is a covered sex crime, and neither 4B 1.1 nor A of this guideline applies, and the defendant engaged in a pattern of activity involving prohibited sexual conduct, we apply this enhancement.
Right, but
and
I don't know.
Yeah, go ahead, Judge.
Sorry, so I'm just stuck on this language. The instant offense of conviction is a covered sex crime. So what? I don't understand. I must have stared at this thing for hours, and I do not understand what the commission intended in a case where there are two offenses of conviction and one is a covered sex crime, but one is specifically excluded. How can you impose this penalty without effectively imposing it, at least in part, on the excluded one?
Well, the government's position and our reading of this, Your Honor, is that offense of conviction refers to all offenses of conviction. And so in this case,
it's so singular, the defendant's instant offense of conviction. It just sounds like, it doesn't sound like all offense, any of or all. But so you read that to mean, you read this basically to mean in any case in which one of the defendant's instant offenses of conviction is a covered sex crime.
Yes, Your Honor. And so once obviously reading it that way, then it does not, it doesn't matter which we are using.
Right, if you read it that way, it's fine. It's just that that's not what it says. But
and I'm sorry. So I understand.
I'm so frustrated by this.
And so, just so I understand, I confess it's not apparent to me either. But the reason you're saying that, in essence, is because we go through this sequentially. And so, by the time you get to Chapter 4, all of the convictions are combined at that point. Grouping has happened in Chapter 3, and so there is only one. I mean, is that the argument? I mean, that seems like a interesting one, I guess, is what I would say.
Well, Judge, it is, as Judge Harris pointed out, an oddly singular wording when, of course, defendants are convicted of multiple offenses at a time quite often. And so reading it, yes, the government's argument is that reading it kind of as in combination with how we apply the guidelines, that it simply refers to any offense of which the defendant has been convicted. And in the case we cited, the 11th Circuit case, McCree, coming out, and it doesn't directly address the argument, although it appears that it was raised by the defendant, coming out of his guidelines calculation, the child pornography offense was driving his calculation as well, and not a, quote, covered sex offense as defined by this guideline. And the 11th Circuit found applying the enhancement proper in that case. And again, it doesn't really have an extended explanation of that. But the government believes that the explanation is simply the way that we calculate the guidelines and through the different chapters, that when we get to Chapter 4, it is simply referring to an offense of conviction that the defendant has been convicted of, and that's in line with the purpose of the guideline as well, which is to put this enhancement, to give an additional tool to district court judges to impose this enhancement on particularly dangerous offenders who pose future threats.
I mean, counsel, this is Judge Harris. I fully appreciate your argument, and this is very helpful. I'm frustrated only because I find the text of the guideline itself sort of impenetrable, and I feel like the one thing we sort of know about the purpose is that they did not want to include child pornography offenses. Those are specifically excluded, pulled out of the category of covered sex crimes. And so I have a real concern that in a case like this, where it's the child pornography counts that are driving the whole sentence, they're the ones that get you into this range anyway, that to then apply this enhancement, which is not supposed to apply to child pornography offenses, it's not clear to me that it's consistent with the purpose.
Well, Judge, I believe it is consistent with the purpose, given that the defendant was convicted, in fact, of a covered sex offense. He was convicted of attempted sex trafficking of children, and despite the fact that coming out of Chapter 2 does not drive his guidelines convictions, when we get to Chapter 4, that's the case, that he has that offense of conviction as defined by this guideline, and that applying the enhancement then in that circumstance is proper under the guidelines. I certainly understand the court's confusion.
And that's just so I understand that's also part of your, Chapter 4 is about the person, Chapter 2 is about the offense.
Yes, Your Honor, correct. Yes, but when we get to Chapter 4, the purpose is more about, we see it in the career offender guideline as well as this guideline, the purpose is about the person and the history and the danger they pose and bring to the court, which is why these enhancements have been put in place. And so it doesn't matter, again, it doesn't reference and doesn't matter what is driving the Chapter 2 calculation and which offense we are using for that purpose, as long as the defendant has been convicted of a covered offense. They should be subject to this enhancement and sentenced under this guideline.
Can I ask you, the defendant, I think, if I'm remembering correctly, argues in part that this should be a rule of lenity case, that this is kind of hopelessly ambiguous. The government had two different positions before the district court, that's enough to get us to ambiguity. And in cases, at least of grievous ambiguity, we've said that we would apply the rule of lenity to the guidelines. So why is that not right?
I think, Your Honor, it simply is that while, again, it's defined fairly singularly, offense of conviction, but there are multiple in this case, and that it is not ambiguous such to trigger the rule of lenity, because the defendant was convicted of a covered sex offense as defined by this guideline, and should be subject to this enhancement when we get to Chapter 4.
And you don't think we can put any weight on the fact that the government changed its position on, that the government, when the government submitted its first sentencing brief, it said you can't apply this?
Well, Your Honor, I think that once, I certainly understand the court's concern about that. I think the government consulted with probation, did the research. I think looking at specifically, the double counting case and McCree cases, which the government cited then in its second sentencing brief when looking at this enhancement.
But neither of those actually addresses this problem, right? It's not that you found case law that addresses this issue.
Correct, it does not. But I think in McCree it is clear that the child pornography offenses were the offenses driving after grouping the offenses driving the offense level. So it's similar to this case, but addresses the double counting issue, but more similar than Dow in that sense. So Your Honor, the government, of course, did change its position and tried to get the position that it felt was consistent with how the probation office had determined to apply the guidelines and was consistent with the law on that point. And as I've already, I don't want to rehash it too much, stated, I do believe that when we look at moving through the guidelines and the purpose of Chapter 4 and how it is applied, that it is properly applied in this case, as the district court found. And I'd be happy to address any other issues, and I can briefly turn to the issue raised by the defendant regarding the search warrant in this case, that the search warrant provided ample details supporting a probable cause determination, and the purported omissions that the defendant points to are neither the type of omissions that are designed to mislead, nor are they material to a probable cause determination. When the confidential witness came to law enforcement to report that the defendant had showed her child pornography and asked her if she had access to minors, law enforcement then took several steps to corroborate that information. Not only did they corroborate the details about the defendant that the confidential witness had given to them, they actually gave her a recording device and had her engage in recorded phone calls with the defendant in an attempt to corroborate what she was telling them and gain additional evidence to support that and corroborate that information. And of course, the magistrate reviewing the warrant must take all of this into account in determining to issue probable cause, and I would submit that there is no reason in this case to believe that was the bell.
The affidavit, I guess, hinges on CW's credibility, and the district court said, I don't know what more the officers could have done, because there was, as I understand it, you had face-to-face conversations with her, and they had. And my recollection is that the agents had CW identify Haas in a photograph and identify all of his contact information, resident, phone number, address, and the color and model of Haas's car. And then the question is, are these mundane details that didn't have any bearing on the credibility of CW, but I think Illinois v. Gates says mundane details can add up, but she's making claims that Haas was assisting her in the receipt and production of child pornography, and the affidavit says, and I don't think this was wrong, that the agents actually verified this testimony by recording two telephone conversations that CW had with Haas, and it's very unusual that Frank's hearings are given in a case where there are omissions rather than false statements. And the reason is it's always easy to say, well, you should have included this, you should have included this, and the rest. And if you start down the road and have Frank's hearings with respect to every affidavit that could possibly have included more information, you are disturbing the calculus of incentives and discouraging officers from actually relying and getting warrants. And the Supreme Court has made clear many times that you want to structure incentives in the direction of getting a warrant, and innumerable Franks hearings over omissions. They seem to me to go in the opposite direction. Let's say the district court said at the end of it, what more could they have done?
Yes, Your Honor, and I think specifically here where there are recorded phone calls that law enforcement reviewed and, of course, summarized in the affidavit, this affidavit, of course, does not even entirely hinge on the confidential witness's credibility, where you have these recordings that back up precisely what she is saying. I know that I am certainly out of time, so if the panel does not have any further questions, I would simply reiterate the points we made in our brief, that we believe this court should affirm the defendant's conviction and sentence.
All right. Judge Harris, do you have any more questions with respect to any of this?
No, thank you.
All right. Judge Richardson?
No, thank you.
Okay, let's hear from the appellant. Let's hear the appellant's rebuttal.
Thank you, Judge. So many things I need to get to in my rebuttal time. Turning first to...
would you mind starting with 4B1.5?
Oh, that's what I was going to do. Thank you.
Right.
So 4B1.5B, first off, there aren't any cases that we found, and it doesn't appear that the government has found any cases either that address the issue of what an instant offensive conviction even means. It is hopelessly confusing. What, as Judge Harris pointed out, what's driving the guidelines in this case, or what are driving, are the child pornography convictions. And that is obviously because of the grouping. The guidelines all the way through Chapter 2 are multiple plural, and there are offenses of conviction. And then we get to 4B1.5B, and the Commission uses the term instant offense of conviction, and the very provision that drives this guideline range is excluded from the definition of instant offense. I don't know where to go with that. I was hoping I could come up with some kind of argument that would say that
isn't in light of the dialogue that we've been having, isn't the focus of 4B1.5 as our earlier Dowell case said, to impose an enhanced period of incarceration on criminals who present a continuing danger to the public. And if we sort of clear away the brush and understand that is that you have one covered offense, and then you have the question of, does the criminal who has the covered offense present a continuing danger to the public? The assessment of a continuing danger to the public, isn't that the kind of thing, if applying that sort of standard, the kind of thing that we would give some respect to the district court's finding on, because the district court is likely to have much more of a handle on whether the particular individual is or does not present this continuing danger. So what's wrong with looking at it that way?
It almost presents, I mean, as you put it that way, who do we give deference to? Is it the district court judge or the commission that wrote the guideline? They use the singular instant offensive conviction. It's not clarified. And I still think it's ambiguous. I understand the argument that it's part of the animating purpose of Chapter 4.
Can I ask a slightly related question? So when we look at, and I don't want to say that I've looked at all of them, but if we look at Chapter 4 as a general matter, you think about criminal history categorizations, all these sorts of things, it always uses the singular, right? So it seems to throughout, 4A and 4B to refer to the instant offense. And yet, when we do that in 4A, for example, for like the 15-year rule for a look back, we don't pick one of the offenses, right? We look in whether it's within 15 years of any of the convictions, right? So, it seems like in lots of other areas in Chapter 4, we understand instant offense to refer to the instant, to all of the offenses, right? To all convictions, right. And that's consistent throughout Chapter 4. It's not unique to this provision, right?
No, I agree with you, but I think in every other instance in Chapter 4 where we're essentially going back through somebody's criminal history for the most part, and we're looking at them conviction by conviction. So that we're looking at does this instant offensive conviction, did it happen more than 15 years ago? And then we're going on to the next one. Here,
right, but in a scenario where we have, let's imagine the case where you have two different drug distributions, right, and they're a year apart, and you have a prior conviction that is 14 years before the earliest of the distribution offenses. We don't look at which of those distribution offenses is driving the guidelines. We say, well, since that prior conviction is within 15 years of either of those two distribution offenses, it counts for criminal history, which runs against both of them, even though the second distribution offense in my hypothetical would not be, it wasn't within 15 years of that. So the look back includes both in 4A.
I agree with you on that. It does look back, and it does not specify which of the offenses that you're looking at. But I don't know. I think that the confusion on this is the fact that the child pornography is explicitly excluded, and that makes it confusing when the court uses the singular instant offensive conviction. And so, number one, that's what drove the.
Well, one of the things that does concern me both with the 2G2 and the 4B1.5 is that you're in each case urging us to overturn the application of the enhancement on the one case where the individual was perfectly aware that the people he was attempting sex trafficking with or molestation were children, and then we're asked to overturn the 4B1.5 in the case of an individual whom, at least it seems to me, in light of his sexual molestation of 11-year-old and the attempted trafficking and procurement of the young underage girls, to represent a clear continued danger to the public. And I wonder, when you take these arguments you're making cumulatively, are we not eviscerating the purposes, the clear purposes of these two guideline enhancements, which taken together, what the Sentencing Commission is trying to do is to take an individual with this perfectly sordid history and make sure that he gets an appropriate sanction. And here it seems to me that clear primary purpose could be undercut here by hyper-technical readings that I don't think are compelled by the text, and maybe the confusion about some things invokes the rule of lenity. I grant you that there's a certain amount of confusion here, but before invoking a rule of lenity, there's got to be a reason for invoking the rule of lenity, and I don't know that we have that reason where the district court has found somebody to be a real continuing threat to other minors whom he would attempt to molest or traffic or abuse in some kind of way. I just worry about the cumulative effect of these two enhancements that you want to overturn, and in each case it seems to me that we're thwarting a fundamental purpose, which is to take somebody with this, as I say, perfectly sordid behavior and chop the sentence way down.
I'm sorry.
It just makes me end up in makes me feel uncomfortable about that when you take the totality of this and what it involves.
Judge, I completely understand the impulse. I have very bad facts here.
Hopefully, it's more than an impulse, but that's
I understand. I understand the careful reasoning, Judge. I have bad facts. There's no question about it. What Mr. Haas was convicted of is uncomfortable, and it's bad. It's bad. And now I'm going to speak from my perspective. The impulse or the urge at that point, looking at facts like this, is to fix, if you will, or find a way out of situations where the guidelines in the situation with 2G 1.2b, where I think on its face the guidelines don't apply, and to then look at the animating aspect of the guidelines rather than the words. And in the case of 4B 1.5b, to overlook the ambiguity that's patent on its face, because
all I can say to you is that of course textualism is very important here. I don't think that textualism drives me ineluctably to the conclusions that you would have me reach. But I think that sentencing is factually driven. It is a different exercise from many other things, and there is a large factual component here, and district courts are to be given some discretion in applying that, and it's supposed to be individualized, and it's supposed to be factual. And when you ask me to ignore the clear purpose of things and agency principles and the fact that his behavior clearly marks him as a future risk and a future danger to young girls, I'm just I just don't know, because I think sentencing is supposed to apply common sense, and I think that sentencing is to apply facts, and I think sentencing is to look at individuals and what individuals what they warrant and what they merit, and that is why the guidelines give district judges the opportunity to vary from the guideline range, either upward or downward, when the facts of the case warrant. And so it isn't quite, it is to an extent the rigid exercise that you posit, but it's not exclusively the rigid approach that you advocate, because to me it seems a mixed situation where individualization applies, facts apply, purposes apply. If the textual reading was a slam dunk, okay, you know, I grant you that, but it is not a slam dunk, and that is why these other purposes of sentencing and things, that is why they kick in. And I'm just, you know, being frank about it, and I, you know, maybe it is what you said in all good faith was an impulse. Well, if it was an impulse, I guess I own it, because I think what happened here was so doggone sad, and I think of the life of this 11-year-old minor girl who's been ruined by this, and I think also what would have happened to those other girls had they been produced. And so yes, maybe it is an impulse on my part, and I would put the impulse aside if I thought those enhancements were the kind of slam dunk that you make you make you an able advocate, and I appreciate that, but I don't think they're slam dunks. And this individual wreaked havoc with people's lives, and wanted to wreak havoc on many, many more, and took substantial steps in that direction. It wasn't some academic interest, and it wasn't some fantasy or whatever. He was doing everything he could to have the little girls produced for him so he could ruin their lives too. And I just don't see, it doesn't seem to me appropriate, and I may be the only one that feels that way, but it doesn't seem to me to be appropriate in this case to adopt views of those enhancements, which I do not think are compelled.
Your Honor, I hope I didn't offend you by using the word impulse. I would just say this.
You did not offend me. You've earned my respect.
I would just say this to the panel regarding the sentencing issues. Sentencing discretion is, as you pointed out, it's fact intensive, and it looks at both the person and the facts. But it has to start with the proper calculation of the guidelines, and then the court's discretion kicks in. And if this case is remanded, I would imagine it's very likely that he would still earn himself, my client, a life sentence. I don't know that though. But that's where the discretion should be at sentencing after the guidelines are calculated correctly. And so I won't go back through my arguments again, but I would ask at a minimum that this case be remanded for sentencing under the recalculation of the guidelines.
All right. Judge Harris, would you like to ask anything more of this gentleman?
No, thank you.
Judge Richardson?
No, thank you.
All right, I want to thank you both for your arguments. They've been quite able, and counsel, you haven't offended me in the slightest, because I always appreciate a good argument, and I think you've made one, and both of you leave with my considerable respect. Have a nice afternoon.
Thank you,
And
Judge.
we will adjourn court.
Thank you.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court. And judges,